Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
Registering a trademark is often seen as the finish line. In truth, it is only the beginning. A trademark certificate does not enforce itself. The real responsibility lies with the trademark owner, and that responsibility is ongoing. Policing your marks is not optional. It is a strategic imperative that determines whether your rights remain valuable, enforceable, and respected in the marketplace. Intellectual property offices such as the USPTO, EUIPO, or the DPMA register marks, but they do not actively monitor the market on your behalf. That job falls entirely on the owner. Without consistent vigilance, the risks are enormous. Unchecked misuse can dilute a brand's distinctiveness. Over time, customers stop associating a word or logo exclusively with your business, and in extreme cases, a once powerful trademark can even become generic. History gives us famous examples. Words like aspirin and Xerox, which began as strong trademarks, slipped into common language when policing failed. The law also penalizes inaction. In many jurisdictions, the doctrine of laches applies, which means that if a business waits too long to act, courts may deny relief altogether. Acting late is often as damaging as not acting at all. And of course, the longer infringement continues, the more expensive it becomes to stop. A small problem that could have been solved with a cease-and-desist letter may turn into full-blown litigation, costly rebranding, or even reputational collapse. So, what does active policing actually look like? It begins with the registers. Owners need to watch national, regional, and international trademark databases, spotting new applications before they become registered. But it does not stop there. The digital world is now the primary battlefield. E-commerce platforms like Amazon or Alibaba are rife with counterfeit goods. Social media is filled with impersonation accounts and unauthorized uses of brand elements. Domain name registrations must be tracked to stop cyber squatting or typo squatting, and search engines and paid advertising must be monitored to catch competitors using your brand as keywords to divert customers. Even within a company, vigilance matters. Affiliates, distributors, and licensees must follow strict brand guidelines, and employees should be trained to recognize and report potential misuse. Given the scale of the task, manual monitoring is no longer realistic. Technology fills the gap. AI-powered monitoring tools scan vast databases and platforms around the clock. They can recognize logos, analyze text across languages, and even detect patterns that may predict future infringement. Alerts and filters help owners focus on the real threats rather than being buried in irrelevant noise. At the same time, simple tools like Google Alerts can provide useful signals of brand mentions online. But monitoring alone is not enough. What matters most is how a business responds. Cease and desist letters are often the first line of defense, a fast and relatively inexpensive way to assert rights. When an infringing application is still pending, opposition proceedings offer an administrative route that is usually quicker and cheaper than court battles. If the mark is already registered, cancellation actions may be necessary, especially if the mark has not been used. In severe cases, litigation becomes unavoidable. Online, takedown requests under mechanisms like the DMCA can remove infringing content quickly. Whatever the action, documentation is critical. Meticulous records of infringements and enforcement efforts create a strong evidentiary foundation for future legal action. This is where legal experts play a decisive role. Trademark law is complex, and enforcement requires judgment. Attorneys interpret monitoring reports, assess the seriousness of conflicts, and advise on the most effective strategies. They navigate jurisdictional differences, manage deadlines and formalities, and provide the legal force behind oppositions, cancellations, and litigation. For companies with extensive or international portfolios, legal counsel also ensures that renewals, expansions, and filings remain aligned with broader business objectives. The bottom line is this: policing your marks is not just a defensive chore. It is a vital investment in your brand's value and future. Without it, You risk dilution, financial loss, and erosion of trust. With it, you preserve distinctiveness, strengthen reputation, and secure a competitive edge in a global market that never sleeps.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.